Like, who's here on Macedonio? Claudio?
I'm here, Judge.
Yes, where is he?
Present, Judge.
All right, come forward. All right, state, did you tender an offer?
Yes, Judge. Yes, Judge, received that offer today. I think we'd like to reset it for a plea. I just want him some time to consider that. I have a couple other things that I want to ask him to do. So that the court would be more inclined to follow our agreement. And if we could have that time, we'd be very appreciative of that, Judge.
Okay. How old are you?
I'm 48.
Norma? Recall this for March 27th. That's your plea deadline date.
Thank you very much, Judge.
Welcome.
May we be excused, Judge?
Once he signs the reset form.
Absolutely.
Just have a seat and they'll give you the reset form.
Thank you, Your Honor.
You're welcome. Who is here on Fidencio Gonzalez? Hello.
Hello, Judge.
So do you have a conflict or no?
We don't have a conflict, Judge, and the discovery is being provided. I've provided the DA's office with a flash drive last week, and they are getting me the discovery. This is one where the SID number isn't working, the name isn't working, the JN numbers aren't working. We can't get anything through.
But there's no conflict, because last time
No.
you were here, you said you needed to see.
That's correct, Judge.
Okay. And state, what's the issue with discovery?
That I don't.
That's what's going on, Judge. The e-discovery system isn't working on this particular case because I think my guess is there's a murder case that's not the defendant I'm sorry, Fidencio isn't the defendant on that case, but it's tied to a murder case. And it appears that everything is under that number and I can't access that number. So Jason has been kind enough to put it on a flash drive for me. So I gave him a flash drive and he'll have it to me.
All right. All right, Ms. Ferguson.
Yes,
I need this recalled in 30 days.
April 17th.
All right, we're gonna come back on April 17th. At that date, state you need to be prepared to tender an offer.
Yes, sir.
All
Thank
right,
you.
is there anything else?
That's it.
All right, once you sign the reset form, you're excused.
Thank you.
You're welcome. And Tony, your client needs to be on time for next time.
I'll let him know.
Thank you. Luis Ura. Court is calling 2024 CR 01109 State versus Luis Ura. Can I have parties announced for the record?
Andrew Harris,
Hector Ruiz Jr. for the defense.
And are you Mr. Okora?
Yes, Your Honor.
Just 1 second. Counsel, have you received all discovery and did you review it with your client?
We have.
Court will find that the state is in compliance with discovery. Is there an application in this case?
There is.
Did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do wait.
So are you proceeding on the indictment as presented?
No, Your Honor.
Any objection?
No objection from the defense.
Mr. Okora, did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand, in count one, you're charged with the offense of aggravated assault with a deadly weapon? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you're giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I feel that he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I feel that he is and was.
Mr. Okora, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promise you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on count one. They're asking that your punishment be assessed at a cap of 6 years in the prison. There's a $2,000 fine. State is silent on your application. They're taking consideration night mag number 760070. There's to be restitution and no contact to the complainants. Did you understand that to be the plea?
Yes, Your Honor.
And did you understand if the court were to determine that there is a weapon used, the court would make an affirmative finding of a deadly weapon?
Yes, Your
All right, defense, is that the plea?
It is.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there many such motions?
There has not.
Then to count one, how do you plead? Guilty, not guilty, or no contest? State any evidence.
State offers exhibit number 1 and attachments.
No objections from the defense.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits one and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Counsel, if you want to set this for a PSI, it'll be 8 weeks. But if you would like, what we can do is I can reset it for a sentencing and you can bring in whatever witnesses you would like to bring in. And I'll ask the state for his criminal history. So which would you prefer?
We're gonna bring in several witnesses, Judge.
All right, so are you waiving the PSI then?
Sure.
All right, so what date would be good for you, counsel?
I would like to look towards April, Judge, just to make sure that we can coordinate with the individuals. At this point, I have the 22nd or the 23rd available.
I can do it the first week in April.
I am in Del Rio and then Eagle Pass. 3 days of the week, so I'll be out from Monday through Thursday.
Mhm.
The following week. The earliest I would be able to do is the 10th.
All right, Ms. Ferguson. If you'll put this for April 10th for sentencing and the PSI is waived. And we can go off the record, what ended up happening, the state is silent on your application. The only thing I'm gonna need from them is your criminal history if you have any.
There,
And then I will hear whatever witnesses or evidence your attorney wants to present to the court. And then I'll make my decision on your application based upon any evidence that I hear or receive, okay? Do you have any questions about anything? All right, once you sign the reset form, you'll be excused. Just have a seat and your attorney will bring it to you. You're welcome.
thank you, Judge.
You're welcome.
Byer.
Oh, just 1 second. I'm sorry. It didn't pop up in Odyssey for some reason. Let me try it again. Domingo Villa.
Afternoon, Your Honor.
Good afternoon. All right, state, did you tender an offer?
Yes, Judge. We did receive an offer today, Your Honor.
All right.
I would like an opportunity to review that with Mr. Villa in my office along with the evidence, and at the next setting, we'll be prepared to either accept it, counter, or set the matter. I'll get it lined up for trial.
How old are you?
19.
All right, Norma. Set this for April 21st. That's your plea deadline date.
Thank you, Your Honor.
Once you sign the reset form, you're excused.
Thank you.
You're welcome.
Have a good day, Judge. Well,
You
I've
too.
got one more, I'm sorry.
And state on that one, if you'll prepare acknowledgement of discovery.
I'll make sure we get it turned in, Your Honor.
Thank you. Christina Martinez.
It's good. Yeah, it's good.
Hello, Ms. Martinez. All right. So what is the update on the evaluation?
2 weeks ago, she was found incompetent. We should be going back again to that court. She wanted to order some other testing because it was believed, and after she's done with her treatment, that she will become competent. That'll take a while. So that's where we're at right now. And I think we got another hearing this week to discuss the other testing that the state was smart to give her some more evaluations to try to help her understand her problems better, as well as the people that are treating her.
All right, Norma, set this for the fourth week in May, please.
Fourth week in May.
Yes. Isn't that a holiday?
Why not?
27th.
All right, May 27th.
Oh, excuse me.
All right, we're gonna bring you back to this court on May 27th. We can't go forward on anything until a doctor states that you are currently competent, okay? Do you have any questions?
I don't understand why, you're just, it's just the thing is that I have a charge for Cordova,
I'm sorry, you have what?
because something, that I was trespassing and that I had spit on his mouth, which is I didn't, I had a.
All right, so
wash
let
my
me
mouth.
So let me
And it's
explain.
already 3 times a year.
So it's probably best for
Four times.
you not to speak about your case. All right, so, and I just say that for your protection, because your attorney may have different defenses that he wants to put forth in the court. But what I can tell you is, until I get something from the magistrate's court saying that you're competent, I can't move forward or do anything with this case. You understand?
Okay.
All right. All right, thank you so much.
Thank you, Your Honor.
You're welcome.
And I'd be excused.
Yes, you may be excused.
Thank you, Your Honor.
Mr. Sullivan, you still have another client.
Oh, I do?
Yes, he's gonna go and get him.
Melissa Johnson.
Gonna go get
If
him.
you can put her up.
Okay.
Thank you.
Guerrero.
Oh.
Yes, you can. Matt, can you go to the second one?
Right on Matthew Salazar.
Tyler Ketchum. And Deputy Laura, if you can make an announcement for Tyler Ketchum in the hallway.
Tyler Ketchum.
Yes. It's actually Tyler Richard Paul Ketchum. Carissa Johnson. All right, this is contested, correct?
We're gonna put you to the number 5, Judge, the felony report.
Right. Court is calling 2020 CR 11653, State of Texas versus Carissa Donora Johnson. Could I have parties announced for the record for the state
Ashley Jones for the state.
defense?
Jim Wheat,
And are you Miss Johnson?
Yes, ma'am.
Your Honor, I'm sorry. I don't know.
Sure. If y'all want to step back and confer, you can.
Please, Judge.
All right, just have a seat and I'll call you up when they're ready. Who are the attorneys on Matthew Salazar?
Ready?
State, are you ready?
Yes, Your Honor.
Okay.
I do.
Yeah.
That's.
I'll give it.
My notes are on that. Okay,
If you want to give him that back, I can give you mine.
that's fine. She can.
All right. All right, court is calling 2022 CR 3264 State versus Matthew Salazar. Excuse me, guys, we're on the record. You need to ask the deputy to move you down there. State versus Matthew Salazar. Can I have parties announced for the record for the state?
Ashley Jones for the state.
Robert Porter for Mr. Salazar.
And are you Mr. Salazar? Are you the same Matthew Salazar who was placed on community supervision in 2022 CR 3264 for the offense of assault of a pregnant person on December 8, 2022 for a term of 10 years? Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor. State is moving forward on violation of condition number 14G on or about the 14th day of May 2024 in Bexar County, Texas. The defendant, Matthew Salazar, did then and there fail to apply for, provide documentation of attendance, and comply with all rules, regulations, instructions, and financial agreements as directed by the court and or supervision officer and or the head of or authorized personnel of the following program, battery intervention and prevention program, in violation of condition number 14G.
How do you plead to that? True or not true?
Yes, ma'am. True. Yes, ma'am.
All right, state.
Violation of condition number 39 on or about the 19th day of April 2024 in Bexar County, Texas. The defendant, Matthew Salazar, did then and there fail to submit to an evaluation for placement into the drug court in violation of condition number 39.
How do you plead to that? True or not true?
True. Yes,
Violation of condition number 42 on or about the 7th day of August 2024 in Bexar County, Texas. The defendant, Matthew Salazar, did then and there fail to submit to a substance abuse evaluation with the Bexar County CSCD's Treatment Alternative to Incarceration Program, TAP, in violation of condition number 42.
How do you plead to that? True or not true?
True.
The state will waive all
No.
violations.
No objections.
Did you understand by pleading true to violation of conditions 14G, 39, and 42, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to 14G, 39, and 42? Court will find 14G, 39, and 42 true. Oh, did you all fill out an application, a trial court certification?
Well, he's on probation, so that one should have been one already filled out.
That's okay.
Apologies, Jeff.
Yeah. Well, you know what?
Nice as
They
that.
ran out of paper,
Hmm.
you know, the regular one, so this is what they've given us. All right, is there a proposed agreement?
There is not, Your Honor. We had a partial agreement to plead true to those conditions, so they are not contested, and to waive the other condition, violations. And then I believe we're going open to the court with the recommendation of the state and that's our position.
All right, so are there any witnesses?
No, you don't.
All right, state, what are you requesting?
Your Honor, just given the seriousness of the offense for which the defendant was placed on probation for, he did receive 10 years, probated for 10 years, so he is subject to the underlying sentence for 10 years. For, I do believe he's been on probation since 2022 and he has not done the battery intervention and prevention program. He did have substance abuse problems, and all efforts to try and get him to come to compliance and address those problems have been thwarted by the defense. And so for those reasons, Your Honor, state's position is that he's shown that he doesn't want to be on probation, and the court should sentence him to corrections for a period of no less than 5 years.
All right, and defense, what are you requesting?
Two things, Judge, if I may address a couple of things. We're going to respectfully request that you continue him. A couple of things about the battery intervention program. And he actually was signed up for that back in April. Went to a couple of classes. He was having trouble communicating with his probation department. I showed emails to the state of Texas about that we weren't, I wasn't lying about just probation department just stopped communicating with him after a certain date. So he freaked out and said, I'm not gonna do it. He was arrested, and before this court, I was appointed 2 weeks ago. He made bond. Since then, he got out. He has signed up for the battery intervention program, and he's set for his first class on Thursday.
So why hasn't he followed the court's instruction with regards to felony drug court?
Well, I'm gonna get to that. I'll
Okay.
go one at a time.
All right, I like the one at a time.
He did speak with the probation officer, and she did say that she would make attempts to. That's why.
So, okay. The drug court. The drug court also, Judge, he was notified, and this is through a series of emails from the state of Texas that we've shared all this stuff together already. And so we're trying to give it in a nutshell. On 4/22/24, he did not qualify for drug court. Now, since that time, they still asked him to come to the court, I guess, to tell him you don't qualify, what have you. On 4/25, he had called up his probation officer and told them, listen, I've been in the hospital. And they said, well, unless you show us some kind of proof that you're in the hospital, we don't care. As of today, I don't have it printed out, but I did see it, Judge, and there's an officer's court on the tab. He was in Methodist Hospital from 4/27 to 4/29, which lacks it was the 25th, is the day we're talking about, so that's 2 days. However, on speaking with him and his wife, he was sick on the 25th. They had gone to Mission Trails first, which the
All right, so
hospital had
let's-
transferred. So anyway, so the drug court, he
What
didn't
about the
qualify.
19th, April 19th? Because on April 19th, it says that he failed to submit for an evaluation for placement in drug court.
From my understanding, but that was, it even goes back further than that, Judge. I think that the chain of emails go back further than that, about the dates of what was happening and dates being moved.
All right, I need to
So-
see that, because otherwise I'm thinking he would need to go to prison, but I want to see the email in regards to April 19th.
Well, there's gonna be a trail of emails,
Yes.
because they start like all the way back in April.
It's the case codes for the drug court supervision officer.
All right, so if I could see those.
And then the TAP judge, other than the TAP, again, we're taking full responsibility of the TAP because we don't want to do that. But at the end of the day, when it came to the TAP and talking to the probation officer, he was told that they were really backed up and he'd be notified later on, and he was never notified.
Let me ask you
later on.
this, and if your client is drug tested today, is he still going to be positive for marijuana?
He should be clean, Judge, and that was gonna be my second option, Judge. I know there's been a history of the marijuana.
Mhm.
We go back and look at it too, and in fact, when he was back in front of this court, he had just got in or just got out of jail, so he had this, but he's been clean for a month. And that reminds me of something else. He's been going to AA meetings since April of 2024. And I did get a letter from his AA sponsor who says he does AA every Friday. He's been doing it every Friday for the past, since April of 2024. In the alternative, I know the probation had asked for, and we are in agreement, should the court decide not to continue him out on the street, probation is asking for Saturday.
He's saying it's safety.
Oh, I'm sorry, safety. Yeah,
All right, here's my question. Has he done a TAP evaluation? Because in the motion to revoke, it says no TAP done.
I don't think a tap has ever been done.
And does anybody have the court summary?
I have one.
Any objections to the court reviewing?
Right. Not for the fence.
All right, so this is one of my questions from reviewing the court summary. So it says that he claimed that he was already enrolled in BIP with CPS. So I'm assuming that's not true.
Judge, you'll have to, I don't know that answer.
All right, Jenna, raise your right hand. Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God? You can lower your hand, state your name for the record.
Happy Salazar?
All right, so in the court summary, it states that you told them that you had enrolled in BIP with CPS. So is that true or no?
Yes, ma'am. I already did the, I was enrolled with the BIP, but I got incarcerated for CPS but I finished my parenting classes and all that for them.
No, BIP is something completely different from
Better
parenting.
intervention.
Yeah, it says on February 6, 2023, the probationer reports he enrolled in BIP with CPS. On March 10th, 2023, officer inquired about BIP and he started crying, states they are giving him the runaround. On April 12th, 2024, officer inquired about BIP and he stated he sent the packet and has not heard anything. On May 14th, 2024, the probationer called and states he called about the BIP and they told him the price. Officer informed him to register ASAP and he states he will try and get the money soon. Officer received a call on June 11th, 2024 from probation stating if his appointment to report should be rescheduled due to his daughter award ceremony. So the question becomes, did you enroll in BIP through CPS or no?
Yes, ma'am. I did, and then I was enrolled. I enrolled in it.
I don't know about the CPS. I know he had enrolled in this was.
Any objection to me? Does anyone want a search warrant for the cell phone?
We're not gonna do that. We're not gonna do that. That may be, there's a couple of the things on there, Judge, that I need to,
All right.
if that's not. the
I
skeleton.
won't swipe right.
No, that's.
Is this an Android or is this?
It's an Android.
All right, so then I know how to use it to.
There's actually two different phone numbers that a lot of this paperwork was texted to me on, Judge, that I'll be happy to kind of flip back and forth to
Okay,
give you.
all right. Is there anything else?
Not from the state.
Just, again, just a couple of last things, that goes to the allegations, Judge. He is he does work full-time. He works for Lone Star Mobile Home Installers. He transports mobile homes. He's a father of two. Actually a father of three, but he takes care of two full-time. And so we're respectfully requesting either to continue and let him work these issues, and if he can't do that, then probation's recommendation.
All right, so here's the thing. You're getting drug tested today. What are the results going to be? And now's the time to tell me if it's going to be positive. Now's the time to tell me.
I was in jail for the last about a month and I've been out clean. I didn't mess with anything when I got out of jail, man. I didn't do anything, smoke cigarettes. And last night I took NyQuil, that's about it, because I've been feeling sick.
See, so here's the thing. We're doing NyQuil, and the last time there was an issue with alcohol.
But I explained to him I'm sick. I did take it because I was sick last night.
Well, here's the thing. You're not supposed to be taking alcohol at all. Those are not my rules. That's the legislature's
Oh,
rules.
I didn't
You
realize.
can't drink alcohol at the house when you're on probation. Can't do marijuana in your house. Just not allowed.
With Dayquil and NyQuil, like prefer cough and congestion.
No, see, you're not hearing me.
Yes, ma'am.
Let me ask you this. Do you read the label on that? Is there alcohol in that? Yes, there is. Dayquil, is there alcohol? Yes, there is. NyQuil, is there alcohol? Yes, there is. You're not allowed to take anything with alcohol in it.
Sorry, I was not aware of that. I'm sorry. I was just,
You should have been aware
I thought
because
I
you
had
tested
COVID.
positive for alcohol before.
I thought I had COVID, didn't feel good at all.
Well, NyQuil is not gonna help you with your COVID. I mean, I could be, I'm not a medical doctor.
Yes, ma'am.
I play one on TV, but
Yes, ma'am, but I have not changed any drugs or anything.
okay. All right. Anything else from either side?
Not at this stage.
Upper fence.
Probation. So you all don't have a TAP evaluation on him. Am I correct in saying that?
Yes, ma'am, that's correct.
All right. Can we get an expedited TAP on him?
Let me send a check out to.
Thank you, State. You may be excused.
Um,
All right, let's do this. Just have a seat in the box. They're gonna tell me about this expedited test.
Thank you, Judge.
Are you all ready on Carissa Johnson? And probation. Can you tell me the date for out of custody? And I don't want 3 weeks for out of custody. I'm thinking this week.
It's not, I don't think it's gonna happen. They're 3 months out on regular appointments now for TAP. Judge.
And what is it in custody?
In custody, you should be able to do it within 2 weeks.
All right. All right, court is calling 2020 CR 11653 State versus Carissa Johnson. Can I have parties announced for the record for the state
Rick Pena for the state of Texas.
defense?
Jim Wheat for the defense.
And are you Miss Johnson?
Yes, ma'am.
All right. Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Carissa Denora Johnson who was placed on deferred adjudication in 2020 CR 11653 for the offense of criminal mischief, $2,500 to $30,000 on April 9th, 2021 for a period of 3 years? Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor, here today on state's motion to enter adjudication of guilt and revoke community supervision. Violation of condition number 5. In Bexar County, Texas, the defendant, Carissa Lenora Johnson, the then and there failed to report to the supervision officer as directed for the months of August and September 2024, in violation of condition number 5.
How do you plead to that? True or not true?
True.
State will waive all and abandon all of the conditions. Your Honor.
Any objections?
No objections.
You understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes, ma'am.
Court will find violation of condition number 5 true. Is there a proposed agreement?
There's no agreement, Judge.
State, what are you requesting?
You're requesting years in state jail with credit for the time of time served in custody.
Defense, what are you requesting?
Judge, we'd ask for you to take a look back at her file and at the reports from probation. She has tried and has not done all that well in treatment. But during that time, she has been locked up a good bit while working with the court. She also has 240 days. Well, I was told 240, it might be 190, somewhere in that range of the amount of time that she has. And given her history, given the fact that she has worked with the court at different times and looked to work with the court, we're asking only that you give her credit for her time served, which I believe is 190 days. And I know she would, I believe, would like to speak to this too.
All right, you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Melissa Denora Johnson.
All right, what would you like to say?
Just that, with all this that I've been through, like mental health wise, I got back, stable on my, medications. I have learned my lesson. I have been in and out of trouble, but this time I actually stayed with the Center for Healthcare Services. I'm doing better, but I just hope that I can, you know, I don't know what I'm trying to say. I'm nervous.
Oh, that's okay. There's no need to be nervous. I'm just here to listen and hopefully make a just decision in what's right. What I can tell you is, what I want to know is what have you done since you've been on probation? So the violation of condition number 5 tells me that you haven't been reporting. And my understanding is that you were supposed to be at Pay It Forward. And I'm just saying that because your counsel asked me to look over your history. So were you at Pay It Forward? And if you were not, why not? That's a good program.
I wasn't paid for it. I actually finished, but I was let go a week early for my needs, like it was medical release. And I moved on to the sober living and I didn't stay there. I got flagged for not coming in on time and I just didn't stay. When they told me I had to wait 2 hours outside of for the sober living so I can come back in, I didn't stay. I just left. I didn't feel comfortable.
What do you mean you didn't feel comfortable?
I mean, just waiting there outside of the gate. That was one of the things that they do when you're late. When you
I mean,
get
those are
flagged.
called consequences, right?
Yes, ma'am.
Her family is here.
Mhm.
They're in the back. She has a place to go if the court can allow her back out again. And we have that set up.
Well, what I can tell you is, I don't think a judgment satisfied is appropriate in this case. I don't think 2 years is appropriate in this case. You have done some things, but I'm not going to give you a judgment satisfied.
Okay.
All right, so is there anything else from either side?
191 days, Judge, would be fine.
Okay,
No.
yes, state.
Your Honor, Bexar was ordered to SATF on November 1st, 2021, but she failed to surrender at the Byer County Jail placement on
Ah,
December 9th, 2021. You allowed her to attend intensive outpatient treatment, but she failed to attend in August 2nd, 2022. There was a compliance hearing because of that, Your Honor. At the compliance hearing on October 25th, 2022, the defendant was ordered to complete a TAP evaluation, which recommended DDOP. But it did begin, that was in February 24, 2023, but was discharged 3 months later on May 23rd, 2023. Her probation has already been extended and amended for 6 months to include PERF. Entered PERF November 8th, 2023, but was discharged March 4th, 2024 with recommendation for safety. And here we are, Your Honor, after all this time, and can't really help her with probation anymore. That's why state's making a recommendation that it was.
Judge, just a reminder, she has never been arrested before this case. This is the first one in. You gave her deferred. She did not do well, and we're not trying to hold her up as somebody who was perfect on her probation. But the amount of time that she's been in is certainly commensurate with what we've seen in this court on some other cases. And I don't think that it's inappropriate to consider something in that 180 to 190 day range, especially with no prior history.
Well, what I can tell everybody is I treat people as human beings, so everybody's case is different. What I may have given, person A, I don't give the person B because I'm treating people as individuals. All right, counsel, did you go over the trial court certification with her?
Let me have her sign it. All this means is that there's no plea bargain and you can appeal if you choose to.
Thank you.
No, you can say- so we wanted you to go, if you want.
All right, and reviewing the file, I did see that in October, your conditions were altered and amended, and you were admonished not to miss any more appointments. And that was me trying to get your attention, and it did not work. Okay. So as previously stated, the court is finding violation of condition number 5 true. The court is going to grant the motion, find you guilty. Court is going to sentence you to 18 months in the state jail facility. Give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes,
And did you sign it?
yes.
Counsel, I need the copy because
Oh.
you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Do you understand? All right. Yeah. Can you just make a copy of this? All right, because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
And I will also request the therapeutic community. It doesn't increase the time that you're in custody, but they may be able to help you in regards to your rehabilitation. All right, good luck to you. Thank you.
Have a seat, ma'am. File your second chair. Johnson.
And Deputy Laura, if you'll make sure she gets that copy. All right, Robert Porter, are you all ready? Did you receive word from probation how long it would take? Laundry?
They're checking it out still.
Okay. Raheem Asmore.
Judge, I have the letter from the employer when the court is ready.
All right, court is calling 2024 CR 008-783. State versus Raheem Asmore. Can I have parties announced for the record for the state,
Thank you for the state of Texas.
for the defense?
Joanne Nickel for Mr. Asmore.
All right, let me see. And are you Mr. Asmore?
Yes, ma'am, I am.
All right, just one moment. For some reason, Odyssey isn't pulling this case up. Right. So we're here, you're asking that bond conditions be amended?
That's correct, Judge, to allow my client to work.
All right, defense, have you had a chance to review the defense's motion? I'm sorry, state, have you had a chance to review the defense's motion?
Previously, yes,
All right, do you have any objections to the defendant being allowed to work?
state is gonna renew his previous objections made at the last hearing. Yes,
All right, you want to put them on the record?
yes, for the facts made, facts of the case, Your Honor, why state feels that this motion should be denied, this involved, defendant firing the gun at the victim. Shooting the victim with that gun, given that state feels that it should be denied.
Judge, my client would like to be employed. I have a letter from the employer. He has a job currently at Burger King. I feel like this would be a good use of his time. I guess I want the court to be aware initially he's only going to be working from 15 to 20 hours a week, but we're hoping that will increase. His first week is going to be training. He's going to be working at the Burger King for 2 to 3 hours a day, going through training, and then after that, they'll put him on the schedule, but he will not have a set schedule. It will fluctuate depending on the needs, the Burger King's needs.
All right, is he currently on GPS?
He's currently on GPS, yes, Judge.
All right, and so is he driving to Burger King?
I haven't asked him.
No, ma'am, I'll be taking Lyft.
All right. So do you have any objection to his taking a lift to his work as long as he's not driving? All right, so what I can do is he's not allowed to drive. And he's to provide his work schedule to your bonds. I mean, as a condition of your bond, you're to provide your work schedule. All right,
Yes,
so
ma'am.
here's the thing. I understand that Burger King will produce your work schedule maybe the week before or on that Friday. You just need to let them know what your work schedule is.
Yes, Your Honor.
All right, is there anything else?
No, nothing from the defense.
All right, so there's to be no driving, you understand?
Yes, Your Honor, I understand.
All right.
Oh, one other thing, Judge. Sorry, my client just refreshed my memory. I have my client enrolled in the BIP program currently.
Mhm.
Could the court give him permission to go to that class also? I think it's an hour a week. When did you go?
Okay.
2 hours,
Yes,
2 hours per week,
All right. Well, here's the thing. You'll be allowed to attend your BIP course. I think you think that's important. All right, then that will have to be lifted as well because I'm ordering that you're not allowed to drive. Do you understand?
Yes, Your Honor, I understand. Thank you.
You're welcome. All right, if you want to make a copy of that and
Thank you, Judge.
turn it back into the clerk.
I will, thank you.
Thank you. Let's see. Miles Fenton. Brent.
Oh, I'm sorry.
Miles Fenton, come down. All right, court is calling 2024 CR 010751 State versus Miles Fenton. Can I have parties announced for the record for the state? Defense?
Brent Hardy.
And are you Mr. Fenton?
Yes, ma'am.
All right, you entered a plea to count one of no contest. Punishment was to be assessed at a cap of 18 months in the state jail facility. The state is silent on your application. Defense, you waived PSI. Do you have any witnesses?
No, Your Honor.
All right, the court will hear your argument, counsel.
Judge, Mr. Fenton, would, like to address the court.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record. Counsel.
Oh, I'm sorry.
All right, there's something you wish to say?
Mr. Fenton, would you explain to the judge why you think she should grant you probation?
All right, family,
All right, so let's start here. Let's assume you don't have any family. Let's assume you're alone in the world. Why should I grant your application?
because I intend to be a father. I intend to do what our Father has intended for us to do on this earth. Have a family, be a family man, provide something to this world that we live in.
I'll say, so let me ask you this. If you did not have a family to support, then why should I grant your application? Let's
be
assume you
honest-
don't have a family to support.
To be honest with you, Judge, boy, I've been playing basketball my whole life, and that's how I plan to take care of my mother, my father, grandparents, all of my family. I got injured a few years ago, and this whole time I've been locked up, I had a chance to get my body in shape, and it's a critical point in my life, my career, that if it's not now, then it'll probably never be. So it'd be real important that if I did get an opportunity to be free, chase my career, then I wouldn't end up working for somebody else. I can be my own boss and provide.
Mhm.
That would be appreciated.
All right, so nobody's addressing the elephant in the room, which is your charges and what's in the narrative. So you're here for an unauthorized use of a vehicle. Let's talk about that. This case was in the middle of a jury trial. You decided to accept a plea. And according to the facts of these case, there was a medical student, nursing student, comes out, finds that her vehicle is gone. And I'm sure, and if I'm wrong, correct me if I'm wrong. I take no offense to that. I'm sure she had a family to support. That's why she's trying to better herself by going to nursing school. And she comes out, and the car that either her parents got for her or she worked hard to obtain that vehicle is gone. And somebody else is riding around in her vehicle without her permission. And who do you think that person was?
I'm not sure.
It was you. You were riding around in her vehicle. What do you mean you're not sure? Who are you looking for? All right, so you were riding around in her vehicle. There was a video that was entered into evidence. The officers were having you remove your body from the vehicle. And what I remember on the video is the only person in that vehicle when you were pulled over was you. Was there somebody else in the vehicle that I missed?
No, Your Honor.
All right, so what do you mean? You don't know who was in her vehicle. It was you. All right, is there anything else?
No, Your Honor.
All right. This is what the court is going to do. The court is finding you guilty. Court is sentencing you to 18 months in the state jail facility. Give you credit for any time served. And I didn't see any mention of restitution, so I'm assuming there's no restitution. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? And did you sign it?
No, I didn't sign anything.
Is that your signature?
Yeah, what's that for?
All right. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question of what a weapon or ammunition is, you'll need to speak to the state. I'm sorry, you need to speak to an attorney. Do you understand?
That's understood.
I'm sorry, what?
Yes, that's understood. I can't get a weapon or any firearm.
No, you cannot.
Yes, ma'am.
All right, good luck to you.
Thank you, Judge. May I be excused?
Yes.
This is my copy.
Yeah.
Johnson?
Yes.
TAP has told me that the earliest is the 1 week for the TAP and a week and a half for the paper, for the report to come out, be generated, if he's in custody,
1 week.
1 week. Yes, ma'am.
All right, thank you. Jeffrey Guerrero.
Scott Sullivan from Mr. Guerrero. If I could address the court at the start of this hearing.
Sure.
May I go?
Yes.
I, I don't even have this case on my docket today.
Mhm.
And I have been clearly way far behind on how often I should be seeing this man, what we need to be doing with evidence. And he's a great client. He understands and gives me lots of information, but it's not going to be worth anything if the lawyer doesn't go see him. Somewhere in all the 50 hours I've been having to work recently and having to get caught up from being in the hospital last year, I neglected. And so what I told him today is give me 10 days to show to him that I can be the best lawyer for him that I need to be. And I would ask that you set it for next week. And then if I have not done a job that's sufficient for him, I will gladly withdraw on my own, Your Honor.
Alrighty.
I apologize to my client. Ma'am. I don't mean I apologize to the court.
All right, Ms. Ferguson. Recall this for March 24th, so we'll be back on Monday.
Your Honor, thank you, and I apologize.
Oh, you're welcome. Thank you. It happens sometimes. page is Guerrero on? All right, thank you. Hector Ruiz Vargas.
Good afternoon.
Good afternoon.
It's a compliance hearing.
Probation. Do you have the report for the court on this case?
Here it is, if you want to see it.
Thank you. All right. So here's my question for you. Do you want to be on probation or you want to go to prison?
On probation on it.
All right, so then you have some choices that you have to make. A lot of people will say, and they'll see news reports and say, oh my gosh, I can't believe somebody went to prison for marijuana for 10 years. That's a travesty. That's a shame. And what they don't realize is that the person is usually on probation for something else. And part of their conditions of probation is they are not allowed to use marijuana. You understand?
Yes.
Not allowed to drink alcohol. Do you understand? Probation is different than living your life the way other people live their lives who are not on probation. For example, sometimes people who are not on probation, they're like, I can drink alcohol in my house. I can get intoxicated in my house. And guess what? They're not on probation. So they don't have a probation officer to come to their house and say, you're not allowed to drink in your house. Do you understand? Now, if you're drug tested today for marijuana, what are the results going to be?
Positive.
All right. So how often have you been using?
Well, I'm struggling right now, so very, very little.
No, what does that mean? I'm not with you. So
Very little. You told me. Just. I'm just gonna stay up with you.
all right, so here's the thing. You're gonna have to make choices. Either you want a joint and go to prison with your joint, or either you're gonna stop using.
Can I tell you what he told me? Because he's not doing a good job talking.
Sure.
His mother and father moved out of the house recently, left him and his sister, they're like in their 30s, with their children to fend for themselves. And he doesn't have a job. The kids are hungry. I told him I'm gonna give him the address for the San Antonio Food Bank. He's been drinking a lot of water, but still, he told you he smoked some
Well,
weed.
so here's my thing.
They're
One,
hungry.
I don't understand why. How old are you?
37.
All right, you're a grown man and your parents leave and they leave you with whatever children you have, which I don't understand why Child Protective Services is not knocking on the door to see what's going on. But people are
His
like
one
the
child
world.
doesn't live with
Right. But here's the thing. People are like the world falls apart. Oh, I'm in my 30s and my parents have left me and they're not supporting me anymore. How am I going to survive? I need to get a job. I have to eat. That's on you. You're an adult. I don't understand.
He's going on April 9th to the job fair. His probation officer
But now why hasn't
gave
he?
him the flyer.
But here's the thing. Why haven't you already done that? So have you just been laying around smoking marijuana and your parents have been supporting you financially?
No, Your Honor, I've been working off and on painting now. I haven't had a chance to go back roofing because I can't leave out of town.
Mhm.
But I've been doing the painting thing and just paying bills.
No, I can understand why you're not able to leave time for roofing. Me personally, I don't want somebody who is smoking marijuana to get up on my roof. I don't know what's gonna happen. I don't know if stuff is gonna be laid appropriately.
He said by the end of April, he'll be clean. He would test clean, middle to end of April.
I am gonna go to the job fair. I've been telling my PO the same old thing. He's been struggling with.
Mhm.
And mainly I just been paying for food and bills. That's all I'm living for at the moment.
And doing marijuana on the side.
But I don't really smoke that much, Your Honor. Just
You know how much marijuana I smoke?
It's none.
Well, now I'm asking him. You know me, you know how much marijuana I smoke. Do you know how much marijuana I smoke? None. Right? When you have problems, you're supposed to face them. You're not supposed to start smoking marijuana. Because guess what? When your head clears and the fog removes itself, you're still gonna have the same problems.
He would like for you to put him back in intensive outpatient.
I don't know. Well, I'm wondering why I shouldn't put him back, in prison. That's what we're trying to start with. This compliance hearing is for me to see why I can't get your attention because you're looking at 10 years in prison.
Does she
The
have your
NA,
attention?
the NA did help me a lot, Your Honor.
Mhm.
It kept me clean as soon as I got.
But it didn't help much because you went right back to your old ways. The NA meetings are supposed to give you tools to succeed.
I should have done what Saddam said in the first sponsor.
Mhm.
It helped me.
You still can.
Yeah, and here's the thing, guess what? If you would have done this successfully, March 30th, your probation would have been over with.
Just this one.
So you just wasted 4 years of doing nothing and not being successful. And I don't know why probation didn't file a motion to revoke, but they didn't. So here we are in a compliance hearing.
And he
So what
wants to
have you been doing?
comply. What have
Other
you
than
been
sitting at
doing?
home smoking marijuana and drinking water, which back in the day, guess what? That's all we would have, water. All this extra stuff you have, the soda every day. That's just something that now people do every day. But we'd have water. And you know what you would do? You would buy the Kool-Aid that was 10 for $1. And you mix up the flavor. That's it. So. And is that a real diamond in your ear?
I can tell it's not,
And I can't see that far.
but I
and
come
then
right
the
next
grill.
to him.
It's silver.
Mm-hmm. See, people will spend money on what they think is important. The tattoos, the grill, all this other extra stuff. You have to get your life together. This is what I'm gonna do. Probation,
Yes, ma'am.
he's gonna be extended. And he's gonna get extended for 3 years. And then what I'm going to do, make sure that he is tested on throughout the month of April. And I want him on a UA hotline.
You'll never know when you have to go give a sample.
And I want him tested for levels. If the levels increase, if he tests negative and then all of a sudden tests positive, I want a motion to revoke filed.
Okay.
Is there anything you do not understand?
I understand.
Is there anything you need from the court to be successful?
But
You told me.
just your assistance with the NAs and AAs.
I'm sorry, what?
Just the program that kept me on my toes.
All right. Then we'll do daily sober support meetings.
Are they on Zoom?
You can do some online. It's probably best for you to go in person because you need a lot of help. You understand? All right. Thank you.
Thank you.
You're welcome.
Sit in the first row. Have a good afternoon.
Thank you.
I'm gonna go get lunch now.
Oh, hey, you should give some to your client. Yeah. All right, Robert Porter.
Present.
All right. Are you all ready? With your client?
Which one?
Oh, the one that I was waiting for the timeline
We're
on
just
the,
waiting, yeah, we're just waiting on the court.
all right, yes, have him come down. All right, we're back on the record in 2022 CR 3264, State versus Matthew Salazar. Can I have parties re-announced for the record?
Bob Reporter for Mr. Salazar.
And you're Mr. Salazar?
Yes.
All right. So on paper, it appears that you should be revoked, right, and sent to prison. But based upon the information that the court has received from the state and from the defense, there appears to be a breakdown in communication. This is what I'm gonna do. I'm gonna deny the motion, but what I'm gonna tell you, if there is a problem with communicating with probation, you need to let the court know. You understand?
Just, I was notified to come to you if I have any problems, so I just come right in here.
All right, but you didn't do that.
Just now,
So
just
I tell everybody that. Do I not tell everybody that?
if I get scared, I'm coming to you.
All right, so the court is finding 14G, 39, and 42 true. The court is going to deny the motion, alter and amend conditions. And that's going to include a tap in custody and probation.
Yes, ma'am.
You're telling me that the tap in custody will take a week, is that correct?
Yes, ma'am.
All right, so once the tap is completed, and I know you said the actual report will take another week, is that correct?
Yes, ma'am.
All right, so we're gonna do tap evaluation in custody. He's to be released. And then we are going to come back on April 3rd, council.
And I know the court's answer, but I'm gonna put it out there anyway. A judge, if you ordered him in custody for the tap,
Yes.
when he gets out, then I guess he has to reapply again for the bib because his first class was actually scheduled for this Thursday.
Yes.
Okay.
Probation, could you do me a favor?
Yes, ma'am.
Could you send an email to BIP and tell them that Mr. Salazar is in custody for his tap evaluation?
Okay.
And tell them to reschedule his first class. And see if they can schedule his first class. What date did you say it currently is at?
This Thursday. This week.
All right, see if they can schedule it for April 3rd.
Yes, ma'am.
All right, to the court. Yeah, he's to be released once he's completed the tap evaluation.
Yes, sir.
And probation, if you'll let the clerk know when he's completed the tap,
Yes, ma'am.
he'll be released from custody. And then I should have that report hopefully by April 3rd, and you're to come back to court on April 3rd. Do you understand?
Yes.
All right. Could you give him reset form for April 3rd, please? All right, is there anything else?
Sweet.
All right, thank you.
Yeah.
And counsel, can you make sure that BIP knows to reschedule him for April?
I was just giving him the company. that he
All right,
put it
thank you.
Judge, what's the hearing for April 3rd?
I'm sorry?
What's the hearing for April 3rd?
Oh, it's for us to see what the evaluation tap says.
Okay.
Yeah.
Yes, it was waiting for it to.
Oh, this one is County Court 15. They need to sign that. Oh, you did? Okay. Oh, I didn't know you all had taken them in. All right, thank you. Why do people come here to be taken into custody? Why is that?
And then they go to jail. Yeah.
All right, Joseph Grant. Could I see the file on Joseph Grant, please? Hello. So have you had contact with your attorney?
Oh, yeah, he said he had the flu. That's what he told me today.
Norma, did the attorney tell you he had the flu?
Yes, she texted me, Judge, and I sent you the email. Told me not to send it.
Yeah, don't send me texts.
Yes, that's it. I sent you the email.
All right, let me check and see if I have the email.
You have to take off your earrings. Yes, it's free.
All right. So have you had contact with your attorney at all?
Or not really.
All right, is he appointed?
Yeah.
All right, do you want to just have a seat? I'm gonna have some other attorneys come down and speak to you, okay? Thank you. Norma?
Yes.
Call the MAC to come down for Mr. Grant, please. And is Jorge DeLeon out in the box?
No, Judge, he got canceled. His attorney didn't come in or anything.
All right, Norma, recall him for tomorrow and have the MAC come.
Sorry, I'm trying to write that email.
Oh, she
Jose
did come-
Jorge
she did-
DeLeon.
She did come in, Judge, but it was like right before lunch.
No. Okay.
Oh, she's gonna zoom in, Judge. Because she's still at her doctor's office.
Recall it for tomorrow. Yes.
Gonna be doing it. Miss Byer.
Mhm.
They're working on the paperwork.
Okay.
I'm gonna run to county court too because he had the misdemeanor. Just tell them what happened.
All right, no problem. Could I see Beth Martinez, please?
She's out here, Your Honor.
All right, where's her attorney?
Give me 1 second, Judge.
We brought her because she was like one of our few females, and we had her in the back.
Okay.
We got that for, I don't, you have to, forget for that one second. So, mother-daughter relationship. Okay.
Thank you. All right. Beth Martinez, if you can come down. Hello. All right, so what is the update with your treatment?
Well, I don't really,
You don't know.
yeah, know what's kind of going on. I guess with drug court, they kind of said I was terminated when I talked to them.
Mhm.
So yeah,
All right, just have a seat. We're gonna get an attorney here for you, okay?
okay.
All right, thank you.
It's gone. I want a motion to reconsider on that.
Yeah.
So I'm putting it out on order. So should.
Court is calling 2024 CR 4934 and 2024 CR 5788, State versus Emanuel Thompson. Can I have parties announced for the record for the state? Defense.
Eric Hernandez for the defendant, Mr. Thompson.
And are you Mr. Thompson? Counsel, in each of the cause numbers, have you received all discovery and did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Are there any applications?
No, Your Honor.
Mr. Thompson, in each of the cause numbers, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, in each of the cause numbers, do you waive the reading of the indictment?
We waive, Your Honor.
State, in each of the cause numbers, are you proceeding on the indictment as presented?
Yes.
In each of the cause numbers, did you review the documents entitled court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
And the cause number ending in 4934, you're charged with theft of property, 150,000 to 300,000 as a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. And the cause number ending in 5788, you're charged with theft, 2,500 to 30,000 as a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering these pleas, you were giving up those rights? And did you intend to give up those rights and enter into a plea in each of the cause numbers?
Yes,
Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe so.
Do you believe he's currently competent and was legally sane at the time of the offense?
In my opinion, yes, Your Honor, as to both.
Mr. Thompson, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented? Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each of the cause numbers, did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea and the cause number ending in 5788, your punishment is to be assessed at 2 years in the state jail facility. And the cause number ending in 4934, your punishment is to be assessed at 5 years in the prison. In each cause number, there's an $800 fine, no applications. The cases will run concurrently, and the state will take in consideration 2024 CR 5789. Did you understand that to be the plea in each of the cause numbers? Defense, is that the plea in each cause number?
It is our agreement. Your Honor.
State, is that the plea? In each cause numbers, did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No.
Then in cause number 2024 CR 4934, how do you plead? Guilty, not guilty, or no contest?
Guilty.
And cause number 2024 CR 5788, how do you plead?
Guilty.
State any evidence.
No objection to either.
In each cause numbers, did you review the waivers with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. Okay. So we're off the record. I'm just trying to get to the $150 to $300,000 in the one. So far, I see 24,000 in rings. Am I missing something?
There were.
Sure.
I had the same problem, Your Honor. There is, I think the one that is in this county, in Bexar County from Lee Michaels was valued at 197,000.
Okay, and I'm trying to find
It's
that.
kind of buried in the report because a lot of
Okay.
that stuff is from other stuff out of other counties.
Yes. So that's what I'm trying to find.
It's a little bit buried back in there, Megan. There's no dollar sign in front of it. There's no comma.
Oh, 197,000. Okay. All right, thank you.
If you want to value.
All right, so no, but I will tell you, I haven't seen a ring in there for that amount. I'm gonna have to find out if there is, but okay. All right, in each cause number, the court will find there is sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor, we discussed it. Mr. Thompson believes this is the right decision and he's just asking to receive credit for time served. I'm sorry, credit for any time that he's been in custody and other matters out of other counties from the time that this bench warrant was entered.
All right, in cause number 2024 CR 5788, the court is going to find you guilty, sentence you to 2 years in the state jail facility, give you credit for any time served. With regards to time he has when he was out of county, you need to make sure that the clerk is given those dates. This is run concurrent with 2024 CR 4934. Taking consideration 2024 CR 5789. And cause number 2024 CR 4934, as previously stated, the court is finding you guilty. The court will sentence you to 5 years in the prison. Give credit for any time served. There's an $800 fine. Time and money to run concurrent. This is run concurrent with 2024 CR 5788, taking consideration 2024 CR 5789. Is there anything else with regards to sentencing?
No, Your Honor.
And each of the cause numbers, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? Because these are plea bargaining agreements, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, and let me get your dismissal. All right, thank you. All right, we can go off the record. Here's the thing. Yes. No. Here's the thing, sir. All of these material things are just material things, and now you've thrown away your life for nonsense. You understand? You're gonna have to start making better decisions, otherwise you're gonna find yourself in prison for the rest of your life. You understand? All right, good luck to you.
Have a good day, Judge.
Thank you, you too. Anyone else ready? Thank you. And Norma, any word from Mac? All right, I'll send an email. Yes.
Docket, it's just an order through what discovery.
Okay. Norman, have they accepted transfer?
She stepped out, Judge.
Norma Robert Porter is on this, and that needs to be recalled for April 3rd. Court is calling 2025 CR 0000889, State versus Maria Byer.
There you are.
And this is an application, correct?
Correct.
All right. Counsel, you received all discovery?
I have.
Did you review it with your client?
I have.
Court will find that the state is in compliance with discovery. Ms. Byer, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it? Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yeah, Your Honor.
State, are you proceeding on the indictment as presented?
Judge,
They
is there
are.
violence? We don't know.
They are.
We are. We are just proceeding with the indictment as is.
All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? You're gonna need to speak up.
Yes, ma'am.
Did you understand that you're charged with aggravated assault with a deadly weapon? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine.
Yes,
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Byer, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, there's a $1,500 fine. State recommends deferred adjudication. There's an affirmative finding of family violence, a MIC evaluation, and follow all TAP recommendations. And they're saying safety, mental health, and DDR evaluation with recommendations. This is what I can tell you about the plea bargain agreement that you've reached. I'm going to order a TAP evaluation. Whatever the TAP recommendations are, I'm going to follow those TAP recommendations because your plea bargain agreement is for the court to follow whatever recommendations are from TAP. So do you understand?
Yes, ma'am.
So because it says in here, it's safety, mental health, I don't know if that's going to be ordered for you by TAP or recommended. Do you understand?
Yes.
And I am going to order an evaluation for mental health. So it'll be a MIC evaluation. MIC evaluation will determine whether or not you should have the DDRF evaluation. Do you understand?
Yes, ma'am.
So the way I've explained that, did you understand that to be your agreement?
Yes.
Defense, is that the agreement?
It is.
State, is that the agreement?
It is, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any motions?
No, Your Honor.
All right, outside the agreement, the state is asking that your community supervision be for a term of 6 years. that there be 150 hours of community service restitution, no contact with the complainant, HMAC, a TAP evaluation, and follow all recommendations. Did you understand those are recommendations from the state, and I don't have to follow those recommendations? Do you understand?
Ma'am.
All right, then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence?
Objection.
Thank you. You may be excused. Thank you. Did you review the waiver and consent with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept in the evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. So here's my question. In the police report, it keeps saying she's a juvenile.
She's not, Judge.
Okay. All right, and state for the record?
Ashley Jones for the record.
All right, and have you had a chance to speak with the complainant?
We have, Your Honor.
For the court's education, the complaint in this case is the adopted mother.
Mhm.
She will be going to, after any kind of treatment needs, she'll be going to live with her biological mother.
All right. So with regards to living with your biological mother, are there any children in the home?
I think so, yes.
All right, do you know their ages approximately? Okay. So this is what the court is going to do. $1,500 fine probated, affirmative finding of family violence. And did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes.
And did you understand with an affirmative finding of family violence, you're not allowed to be designated as a primary custodial parent?
Yes.
All right, knowing that, do you still want the court to go along with this plea and follow this plea?
Yes.
All right, so there's an affirmative finding of family violence, 6 years deferred adjudication. There's an affirmative finding of deadly weapon. The following is to be done in custody. A TAP evaluation, follow recommendations. MIC evaluation. There's to be no contact with the complainant. Regular reporting by Zoom or in person, regular random UAs, proof of employment or SSI within 45 days of release, no employment as a home health care provider or with minors. And until this mental health issue is stabilized, I'm going to order that you're not allowed to reside in any home with minors.
Okay.
There's to be 150 hours community service restitution. How far did you go in school?
Senior year.
All right, so why didn't you complete it?
Because I got it.
Okay,
She's working on JD right now.
all right, so 150 hours community service restitution. There will be a 50-hour deduction upon completion of her GED. So here's the thing, you can do community service hours if you want to. The heat is about to hit San Antonio, they will have you picking up trash, or you can do something to better yourself. So I'll knock off 50 hours if she completes her GED. I'm not ordering the GED, but if she completes it, 50 hours are come off. And then the remaining 100, I will knock off if you complete some level of higher education or some type of trade school. There's going to be field visits 1 time per month. for 6 months. Let me see. And I'm gonna order anger management. Probation, is there anything else?
Oh, man.
Is there anything else you need from the court to be successful? Is there anything else from either side with regards to sentencing?
Not the state judge.
Stuff in the face.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. Here's the thing, with regards to your mental health, you're gonna have to stay on top of that. So you're probably gonna need to get a case manager. In probation, do a referral for Center for Healthcare Services also. That's just to make sure that you get a case manager to help with your mental health. Housing may be an issue with you. If you have an issue with housing, let probation know. If there's something and you feel that people are not addressing it, you feel like probation is not addressing it, you can always come back to court and I'll address it, okay?
Thank you.
All right, good luck to you.
Take care.
You're welcome. All right, is anyone else ready?
Miss Kim. Court says it's got it. Maybe this one's going on.
Yes.
He doesn't issue one.
All right, David McLean, are you ready?
Judge, we're in the process of altering and amending conditions. And that's kind of what we're working on right now. So we're just waiting for probation to get that done. But otherwise, the state's gonna withdraw the motion to adjudicate.
All right, who's your client?
to Daniels.
All right, can I see that file, please? Yes.
Wayne Daniels.
Okay, so what is happening with this new number one that's in the motion to revoke?
That's gonna be dismissed.
Okay.
And so that was the only allegation in the motion to enter adjudication of guilt. And so the state is going to, we've agreed to alter the amend conditions. They're gonna add a 30-day jail sanction and reorder the fifth class.
The complaining in the new number one, is that the same one that he's on probation for?
I don't think so, Judge. I think it's a different person. Was that the same, different person, right? It's a different person.
All right, well, once they approach, we'll discuss it.
Sounds good, Judge.
All right, thank you.
Yes, ma'am.
And yeah, could you just hand me all of the remaining files? I'm sorry? Oh, just those. Okay, great. No, I'm not.
I think that's probably better than 2 years and or.
Judge, are there any CTD cases?
I don't think there are any remaining. Yes. And again, you will appreciate. situation all over again. I'm just like, all right, could I see, Beth, Nicole, Martinez? Believe there is a motion to revoke.
There is.
There is. All right, could I have a file stamp, please? Court is calling 2021 CR 8476 State versus Beth Nicole Martinez. Could I have parties announced?
Ashley Jones for the state.
Reporter for Miss Martinez.
Are you Ms. Martinez?
Yes, ma'am.
All right, did you review, and counsel, you have 10 days to prepare. Are you ready to proceed?
We are.
All right. And Ms. Martinez, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand that?
Yes.
Are you the same Beth Nicole Martinez who's placed on deferred adjudication in 2021 CR 8476 for the offense of aggravated assault with a deadly weapon on October 12th, 2021 for a period of 4 years? Is that you?
Yes.
All right, state.
Yes, state's going to proceed on violation of condition number 2 on or about the 7th day of October 2024 in Byer County, Texas. The defendant, Beth Nicole Martinez, did then and there fail to submit to drug testing as directed by the court officer, supervision officer, and or duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
True.
State.
The state will waive the remaining violations.
No objection.
All right, did you understand by pleading true to violation condition number 2, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to $10,000 fine?
Yes.
Knowing that, will you still wish to prove true to violation of condition number 2?
Yes.
Court will find violation of condition number 2 true. Is there proposed agreement?
Partially, Your Honor, the agreement was for her to plead true to violation of condition number 2. I do believe defense and I both have different recommendations. The state's recommendation is that she receive some sort of inpatient treatment given the positive UA and the failures to submit. But I do not see any evidence of mental health directives. I mean, the only thing we have is going back as far as 2021. I don't have any current on that to show that there's DPRF.
It's my understanding, Judge, and I think the state checked into this also. Felony drug court, she was in phase 5. They checked into that. What that is, that's the aftercare program. If the court takes notice, the last drug test was back, I want to say 30 UA, it was either September or October, the October one. We don't know if she's pregnant or not. She may have miscarried. They will find out this week. Having said that, Judge, we would like some form of outpatient treatment, maybe weekly UAs. It's like like I told the state, you're running the 440-yard dash, you make it to 435 yards, and then we don't quite finish complete it up. Now we're gonna have to start another 9-month program. At the time this happened, her father had just passed away from cancer. She was trying to take care of the estate and stay in his house. It became overwhelming for her at that point in time. I think that's where she got off track.
So here's the thing I know about felony drug court, because I used to be an attorney for felony drug court. All you had to do was pick up the phone and call them.
I actually did ask them for help. I asked them if I could ask alumni for help with my father's funeral. I even asked if I could put his fundraiser out there, and the case manager at the time, CJ, denied it. She didn't even let me bring it up to alumni.
But now here's the thing, it's not about whether or not you can do a fundraiser. It's about, I'm struggling because I have all of this hitting me at once. I'm struggling in the sense that I may not do my UAs. I may fall out of this program. That's what it's about. It's not, I'm struggling. I've asked you for A, B, and C, and your answer is no, I'm not doing A, B, and C. So therefore, I'm just gonna stop submitting the drug testing. I'm not gonna do any of this.
I actually even did ask my judge if he can move me case managers because we weren't seeing eye to eye. I didn't get that, and I tried to work with my case manager. I did I did good the whole time I was on it.
So
It
let me
was-
ask you this. Here's the question. You asked for your case manager. You tried to work with your case manager and it wasn't working. So your response to that was to do what with your probation?
Mhm. At the time I went with someone, I had too much stuff going on. I was losing
All
my
right, so
father's house.
your decision with probation was what? With felony drug court? See, I'm trying to get you to point, because see,
Well, I know where I messed up. I'm not saying I didn't.
yeah, but so that's the thing. You didn't learn anything from felony drug court, because let me just explain something to you. Everybody in this court has a bad day. Now, some may have a bad day that is not as bad as others. Let me just tell you what happened to me. I had a client who was on parole. I had a parole hearing scheduled for them. You can unfold your arms. I had a parole hearing scheduled for them. I knew that they had mental health issues, and I knew that they were depending on me to be there for their parole hearing. All right, so I'm sleeping, everything's going well. I get a call at 3 a.m. It's a Monday, I get a call at 3 a.m. And you know what that call is? It's from my younger brother, and guess what he tells me? Grandmother died. Now, what do I do in that situation? I know I got a client who's expecting me, who has mental health issues, who maybe won't understand. I know I'm an attorney for children on CPS cases who are not going to understand. So do I just throw my hands up and say, you know what? This is what's going on in my life. I'm not calling anybody. I'm not doing anything. You all handle it. See you later. It's called adulting and growing up. So what did I do? My mom, of course, was upset. She's like telling my brother, why did you call her? You know, it's late. She's far away. She's all the way in another state. But I went and I did the parole hearing because that person was depending on me. I went and visited children because they were depending on me. And then I got a flight and left for home. And I left messages to everybody, hey, my grandmother just died. I'm going to have to go home. So I tell you that to say everybody has problems in this world, but your problems in this world, you're supposed to be able to deal with that. And dealing with that when you're looking at 20 years in prison is to, when somebody says, no, we're not going to do that, then you got to accept that. You're on paper. That's what we called it when I was defense attorney. You're on paper, you're looking at 20 years. So here's my question. Is the TAP evaluation updated or no?
Your Honor, the TAP evaluation I have from probation is from 2021. I do not see, I don't have any information.
All right, so we need an updated TAP evaluation. So I'll find number 2 true. I'm gonna give you a choice. I can deny the motion. You're not getting out of jail today. You're gonna do the TAP evaluation in custody. If the TAP evaluation says you're going to inpatient, you're going to inpatient. Or what I can do is I can revoke you and I'll give you 3 years. Those are your choices.
And how long does the TAP evaluation take?
It won't be long, and that's the right choice.
Will I get my back time if I sign up?
Sure.
There you are.
All right. We're back on the record. Yes. So what do you want to do?
Do the tap evaluation.
All right, so the court will deny the motion, alter and amend conditions to include in custody. There's to be a TAP evaluation. Follow all recommendations. And there's also to be an updated MIC evaluation in custody. And is there anything else that's being requested, State?
Oh, yeah.
And is there anything else you need from the court? Miss, is there anything else you need from the court?
Amen.
All right, and there's to be no residents with minors. All right, thank you.
Thank you, Judge.
You're welcome.
They can validate case.
Yes.